Death penalty and death sentence redirect here. For other uses, see death penalty, disambiguation, and death sentence, disambiguation. Execution and execute redirect here. For other uses, see execution, disambiguation, and execute, disambiguation. For other uses, see capital punishment, disambiguation. Capital punishment or the death penalty is a legal process whereby a person is put to death by the state as a punishment for a crime. The judicial decree that someone be punished in this manner is a death sentence, while the actual process of killing the person is an execution. Crimes that can result in a death penalty are known as capital crimes or capital offences. The term capital originates from the Latin capitalis, literally regarding the head, referring to execution by beheading. Capital punishment has, in the past, been practiced by most societies. Currently 58 nations actively practice it. 97 countries have abolished it de jure for all crimes, 8 have abolished it for ordinary crimes only, maintain it for special circumstances such as war crimes, and 35 have abolished it de facto, have not used it for at least 10 years, and or are under moratorium. Amnesty International considers most countries abolitionist. Overall, the organization considers 140 countries to be abolitionist in law or practice. Capital punishment is a matter of active controversy in various countries and states, and positions can vary within a single political ideology or cultural region. In the European Union member states, Article 2 of the Charter of Fundamental Rights of the European Union prohibits the use of capital punishment. The Council of Europe, which has 47 member states, also prohibits the use of the death penalty by its members. The United Nations General Assembly has adopted, in 2007, 2008, and 2010, non-binding resolutions calling for a global moratorium on executions, with a view to eventual abolition. Although many nations have abolished capital punishment, over 60% of the world's population live in countries where executions take place, such as the People's Republic of China, India, the United States of America and Indonesia, the four most populous countries in the world which continue to apply the death penalty, although in India, Indonesia, and in many U.S. states it is rarely employed. Each of these four nations voted against the General Assembly resolutions. History. Execution of criminals and political opponents has been used by nearly all societies both to punish crime and to suppress political dissent. In most places that practice capital punishment it is reserved for murder, espionage, treason, or as part of military justice. In some countries sexual crimes such as rape, adultery, incest, and sodomy carry the death penalty, as do religious crimes such as apostasy in Islamic nations, the formal renunciation of the state religion. In many countries that use the death penalty, drug trafficking is also a capital offense. In China, human trafficking and serious cases of corruption are punished by the death penalty. In militaries around the world, courts-martial have imposed death sentences for offenses such as cowardice, desertion, insubordination, and mutiny. Anarchist Auguste Vaillant guillotined in France in 1894. The use of formal execution extends to the beginning of recorded history. Most historical records and various primitive tribal practices indicate that the death penalty was a part of their justice system. Communal punishment for wrongdoing generally included compensation by the wrongdoer, corporeal punishment, shunning, banishment and execution. Usually, compensation and shunning were enough as a form of justice. The response to crime committed by neighboring tribes or communities included formal apology, compensation, or blood feuds. A blood feud or vendetta occurs when arbitration between families or tribes fails, or an arbitration system is non-existent. This form of justice was common before the emergence of an arbitration system based on state or organized religion. It may result from crime, land disputes, or a code of honor. Acts of retaliation underscore the ability of the social collective to defend itself and demonstrate to enemies, as well as potential allies, that injury to property rights or the person will not go unpunished. However, in practice, it is often difficult to distinguish between a war of vendetta and one of conquest. Severe historical penalties include breaking wheel, boiling to death, flaying, slow slicing, disembowelment, crucifixion, impalement, crushing, including crushing by elephant, stoning, execution by burning, dismemberment, sawing, decapitation, scaphism, necklacing, or blowing from a gun. The Christian Martyr's Last Prayer by Jean-Leon Jerome, 1883. Roman Colosseum. Islam on the whole accepts capital punishment, and the Abbasid caliphs in Baghdad, such as al-Mu'tadid, were often cruel in their punishments. Nevertheless, mercy is considered preferable in Islam, and in Sharia law the victim's family can choose to spare the life of the killer, which is not uncommon. In the 1001 Nights, also known as the Arabian Nights, the fictional storyteller Scheherazade is portrayed as being the voice of sanity and mercy, with her philosophical position being generally opposed to punishment by death. She expresses this through several of her tales, including The Merchant, and The Jinni the Fisherman, and The Jinni the Three Apples, and The Hunchback. The breaking wheel was used during the Middle Ages, and was still in use into the 19th century. Ancient history. Elaborations of tribal arbitration of feuds included peace settlements often done in a religious context and compensation system. Compensation was based on the principle of substitution, which might include material, for example, cattle, slave, compensation, exchange of brides, or grooms, or payment of the blood debt. Settlement rules could allow for animal blood to replace human blood, or transfers of property or blood money, or in some case an offer of a person for execution. The person offered for execution did not have to be an original perpetrator of the crime, because the system was based on tribes, not individuals. Blood feuds could be regulated at meetings, such as the Viking Things. Systems deriving from blood feuds may survive alongside more advanced legal systems, or be given recognition by courts, for example, trial by combat. One of the more modern refinements of the blood feud is the duel. Giovanni Battista Bugatti, executioner of the Papal States, between 1796 and 1865, carried out 516 executions. Bugatti pictured offering snuff to a condemned prisoner. Vatican City abolished its capital punishment statute in 1969. In certain parts of the world, nations in the form of ancient republics, monarchies, or tribal oligarchies emerged. These nations were often united by common linguistic, religious, or family ties. Moreover, expansion of these nations often occurred by conquest of neighboring tribes or nations. Consequently, various classes of royalty, nobility, various commoners, and slave emerged. Accordingly, the systems of tribal arbitration were submerged into a more unified system of justice, which formalized the relation between the different classes rather than tribes. The earliest and most famous example is Code of Hammurabi, which set the different punishment and compensation according to the different class/group of victims and perpetrators. The Torah, Jewish law, also known as the Pentateuch, the first 5 books of the Christian Old Testament, lays down the death penalty for murder, kidnapping, magic, violation of the Sabbath, blasphemy, and a wide range of sexual crimes, although evidence suggests that actual executions were rare. A further example comes from ancient Greece, where the Athenian legal system was first written down by Draco. In about 621 BC, the death penalty was applied for a particularly wide range of crimes, though Solon later repealed Draco's code and published new laws, retaining only Draco's homicide statutes. The word Draconian derives from Draco's laws. The Romans also used death penalty for a wide range of offences. Ancient Tang China. Although many are executed in China each year in the present day, there was a time in Tang dynasty China when the death penalty was abolished. This was in the year 747, enacted by Emperor Xuanzong of Tang, r. 712-756. When abolishing the death penalty, Xuanzang ordered his officials to refer to the nearest regulation by analogy when sentencing those found guilty of crimes for which the prescribed punishment was execution. Thus, depending on the severity of the crime, a punishment of severe scourging with a thick rod, or of exile to the remote Lingnan region might take the place of capital punishment. However, the death penalty was restored only 12 years later in 759, in response to the An Lushan rebellion. At this time in China only the emperor had the authority to sentence criminals to execution. Under Xuanzang, capital punishment was relatively infrequent, with only 24 executions in the year 730, and 58 executions in the year 736. Lingkai execution by slow slicing in Beijing. Around 1910. The two most common forms of execution in China in the Tang period were strangulation and decapitation, which were the prescribed methods of execution for 144 and 89 offences respectively. Strangulation was the prescribed sentence for lodging an accusation against one's parents or grandparents, with a magistrate scheming to kidnap a person and sell them into slavery, and opening a coffin while desecrating a tomb. Decapitation was the method of execution prescribed for more serious crimes such as treason and sedition. Interestingly, and despite the great discomfort involved, most Chinese during the Tang preferred strangulation to decapitation, as a result of the traditional Chinese belief that the body is a gift from the parents, and that it is therefore disrespectful to one's ancestors to die without returning one's body to the grave intact. Some further forms of capital punishment were practiced in Tang China, of which the first two that follow at least were extra-legal. The first of these was scourging to death with a thick rod, which was common throughout the Tang, especially in cases of gross corruption. The second was truncation, in which the convicted person was cut in two at the waist with a fodder knife, and then left to bleed to death. A further form of execution called ling qi, slow slicing, or death by slash of 1,000 cuts, was used in China from the close of the Tang dynasty, around 900, to its abolition in 1905. When a minister of the 5th grade or above received a death sentence, the emperor might grant him a special dispensation allowing him to commit suicide in lieu of execution. Even when this privilege was not granted, the law required that the condemned minister be provided with food and ale by his keepers, and transported to the execution ground in a cart rather than having to walk there. Nearly all executions under the Tang took place in public, as a warning to the population. The heads of the executed were displayed on poles or spears. When local authorities decapitated a convicted criminal, the head was boxed and sent to the capital as proof of identity, and that the execution had taken place. In Tang China, when a person was sentenced to decapitation for rebellion or sedition, punishment was also imposed on their relatives, whether or not the relatives were guilty of participation in the crime. In such cases, fathers of the convicted under 79 years of age and sons aged over 15 were strangled. Sons under 15, daughters, mothers, wives, concubines, grandfathers, grandsons, brothers, and sisters were enslaved, and uncles and nephews were banished to the remotest reaches of the empire. Sometimes the tombs of the family's ancestors were leveled, the ancestors' coffins were destroyed, and their bones scattered. Middle Ages. The burning of Jacob Rohrbach, a leader of the peasants during the German Peasants' War. In medieval and early modern Europe, before the development of modern prison systems, the death penalty was also used as a generalized form of punishment. During the reign of Henry VIII, as many as 72,000 people were estimated to have been executed. Despite its wide use, calls for reform were not unknown. The 12th century Sephardic legal scholar, Moses Maimonides, wrote, "It is better and more satisfactory to acquit 1,000 guilty persons than to put a single innocent man to death." He argued that executing an accused criminal on anything less than absolute certainty would lead to a slippery slope of decreasing burdens of proof, until we would be convicting merely according to the judge's caprice. Maimonides' concern was maintaining popular respect for law, and he saw errors of commission as much more threatening than errors of omission. Modern era. Mexican execution by firing squad, 1916. The last several centuries have seen the emergence of modern nation-states. Almost fundamental to the concept of nation-state is the idea of citizenship. This caused justice to be increasingly associated with equality and universality, which in Europe saw an emergence of the concept of natural rights. Another important aspect is that emergence of standing police forces and permanent penitential institutions. The death penalty became an increasingly unnecessary deterrent in prevention of minor crimes such as theft. The argument that deterrence, rather than retribution, is the main justification for punishment is a hallmark of the rational choice theory, and can be traced to Cesar Beccaria, whose well-known treatise on crimes and punishments, 1764, condemned torture and the death penalty, and Jeremy Bentham, who twice critiqued the death penalty. Moving executions there inside prisons and away from public view was prompted by official recognition of the phenomenon reported first by Beccaria in Italy, and later by Charles Dickens and Karl Marx, of increased violent criminality at the times and places of executions. By 1820, in Britain, there were 160 crimes that were punishable by death, including crimes such as shoplifting, petty theft, stealing cattle, or cutting down trees in public place. The severity of the so-called Bloody Code, however, was often tempered by juries, who refused to convict, or judges, in the case of petty theft, who arbitrarily set the value stolen at below the statutory level for a capital crime. Contemporary era. Polish women being led to a Nazi execution site in the Palmyra Forest, near Warsaw. The 20th century was the bloodiest in human history. Tens of millions were killed in wars between nation-states as well as genocide perpetrated by nation-states against political opponents, both perceived and actual, ethnic and religious minorities. The Turkish assault on the Armenians, Hitler's attempt to exterminate the European Jews, the Khmer Rouge decimation of Cambodia, the massacre of the Tutsis in Rwanda, to cite four of the most notorious examples. A large part of execution was summary execution of enemy combatants. In Nazi Germany there were three types of capital punishment: hanging, decapitation, and death by shooting. Also, modern military organizations employed capital punishment as a means of maintaining military discipline. The Soviets, for example, executed 158,000 soldiers for desertion during World War II. In the past, cowardice, absence without leave, desertion, insubordination, looting, shirking under enemy fire, and disobeying orders were often crimes punishable by death, see decimation, and running the gauntlet. One method of execution, since firearms came into common use, has almost invariably been firing squad. Various authoritarian states, for example those with fascist or communist governments, employed the death penalty as a potent means of political oppression. According to Robert Conquest, the leading expert on Stalin's purges, more than 1 million Soviet citizens were executed during the Great Terror of 1937-38, almost all by a bullet to the back of the head. Mao Zedong publicly stated that 800,000 people had been executed after the Communist Party's victory in 1949. Partly as a response to such excesses, civil rights organizations have started to place increasing emphasis on the concept of human rights and abolition of the death penalty. Among countries around the world, almost all European and many Pacific area states, including Australia, New Zealand and Timor-Leste, and Canada, have abolished capital punishment. In Latin America, most states have completely abolished the use of capital punishment, while some countries, such as Brazil, allow for capital punishment only in exceptional situations, such as treason committed during wartime. The United States, the federal government, and 33 of the states, Guatemala, most of the Caribbean, and the majority of democracies in Asia, for example, Japan, and India, and Africa, for example, Botswana, and Zambia, retain it. South Africa's Constitutional Court, in judgment of the case of State v. Makwanyane, and another, unanimously abolished the death penalty on the 6th of June, 1995. Abolition was often adopted due to political change, as when countries shifted from authoritarianism to democracy, or when it became an entry condition for the European Union. The United States is a notable exception. Some states have had bans on capital punishment for decades. The earliest is Michigan, where it was abolished in 1846, while others actively use it today. The death penalty though remains a contentious issue which is hotly debated. In abolitionist countries, debate is sometimes revived by particularly brutal murders, though few countries have brought it back after abolishing it. However, a spike in serious, violent crimes, such as murders or terrorist attacks, has prompted some countries, such as Sri Lanka and Jamaica, to effectively end the moratorium on the death penalty. In retentionist countries, the debate is sometimes revived when a miscarriage of justice has occurred, though this tends to cause legislative efforts to improve the judicial process rather than to abolish the death penalty. Movements toward humane execution. Further information: cruel and unusual punishment. A gurney in the San Quentin State Prison, in the United States, on which prisoners are restrained during an execution by lethal injection. Trends in most of the world have long been to move to less painful, or more humane, executions. France developed the guillotine for this reason in the final years of the 18th century, while Britain banned drawing and quartering. In the early 19th century, hanging by turning the victim off a ladder, or by kicking a stool or a bucket, which causes death by suffocation, was replaced by long drop hanging, where the subject is dropped a longer distance to dislocate the neck and sever the spinal cord. Shah of Persia introduced throat cutting and blowing from a gun as quick and painless alternatives to more tormentous methods of executions used at that time. In the U.S., the electric chair and the gas chamber were introduced as more humane alternatives to hanging, but have been almost entirely superseded by lethal injection, which in turn has been criticized as being too painful. Nevertheless, some countries still employ slow hanging methods, beheading by sword, and even stoning, although the latter is rarely employed. In early New England, public executions were a very solemn and sorrowful occasion, sometimes attended by large crowds, who also listened to a gospel message and remarks by local preachers and politicians. The Connecticut Courant records one such public execution on the 1st of December, 1803, saying, "The assembly conducted through the whole in a very orderly and solemn manner, so much so as to occasion an observing gentleman acquainted with other countries as well as this, to say that such an assembly, so decent and solemn, could not be collected anywhere but in New England." Abolitionism. The death penalty was banned in China between 747 and 759. In Japan, Emperor Saga abolished the death penalty in 818, under the influence of Shinto, and it lasted until 1156. Therefore, capital punishment was not employed for 338 years in ancient Japan. In England, a public statement of opposition was included in the 12 Conclusions of the Lollards, written in 1395. Sir Thomas More's Utopia, published in 1516, debated the benefits of the death penalty in dialogue form, coming to no firm conclusion. More recent opposition to the death penalty stemmed from the book of the Italian Cesare Beccaria di Deliti ed el Pene, on crimes and punishments, published in 1764. In this book, Beccaria aimed to demonstrate not only the injustice, but even the futility from the point of view of social welfare, of torture, and the death penalty. Influenced by the book, Grand Duke Leopold II of Habsburg, famous enlightened monarch and future Emperor of Austria, abolished the death penalty in the then independent Grand Duchy of Tuscany, the first permanent abolition in modern times. On the 30th of November, 1786, after having de facto blocked capital executions, the last was in 1769, Leopold promulgated the reform of the Penal Code that abolished the death penalty and ordered the destruction of all the instruments for capital execution in his land. In 2000, Tuscany's regional authorities instituted an annual holiday on the 30th of November to commemorate the event. The event is commemorated on this day by 300 cities. Around the world celebrating Cities for Life Day. Peter Leopold II, Grand Duke of Tuscany, by Joseph Hickel, 1769. The Roman Republic banned capital punishment in 1849. Venezuela followed suit and abolished the death penalty in 1854, and San Marino did so in 1865. The last execution in San Marino had taken place in 1468. In Portugal, after legislative proposals in 1852 and 1863, the death penalty was abolished in 1867. Abolition occurred in Canada in 1976, in France in 1981, and in Australia in 1973, although the state of Western Australia retained the penalty until 1984. In 1977, the United Nations General Assembly affirmed in a formal resolution that throughout the world, it is desirable to progressively restrict the number of offenses for which the death penalty might be imposed, with a view to the desirability of abolishing this punishment. In the United Kingdom, it was abolished for murder, leaving only treason, piracy with violence, arson in royal dockyards, and a number of wartime military offences as capital crimes, for a 5-year experiment in 1965, and permanently in 1969, the last execution having taken place in 1964. It was abolished for all peacetime offences in 1998. In the United States, Michigan was the first state to ban the death penalty on the 18th of May, 1846. The death penalty was declared unconstitutional between 1972 and 1976 based on the Furman v. Georgia case, but the 1976 Gregg v. Georgia case once again permitted the death penalty under certain circumstances. Further limitations were placed on the death penalty in Atkins v. Virginia, death penalty unconstitutional for persons suffering from mental retardation, and Roper v. Simmons, death penalty unconstitutional if defendant was under age 18 at the time the crime was committed. Currently, as of the 2nd of May, 2013, 18 states of the U.S. and the District of Columbia ban capital punishment, with Maryland the most recent state to ban the practice. A 2010 Gallup poll shows that 64% of Americans support the death penalty for someone convicted of murder, down from 65% in 2006 and 68% in 2001. Of the states where the death penalty is permitted, California has the largest number of inmates on death row. Texas has performed the most executions. Since the U.S. Supreme Court allowed capital punishment to resume in 1976, 40% of all U.S. executions have taken place in Texas. And Oklahoma has had, through mid-2011, the highest per capita execution rate. One of the latest countries to abolish the death penalty for all crimes was Gabon, in February 2010. Human rights activists oppose the death penalty, calling it cruel, inhuman, and degrading punishment. Amnesty International considers it to be the ultimate denial of human rights. Contemporary use. Global distribution. Use of the death penalty around the world as of 2012. Abolished for all offenses, 97. Abolished for all offenses except under special circumstances, 8. Retains, though not used for at least 10 years, 35. Retains death penalty, 58, While laws vary among U.S. states, it is considered retentionist, because the federal death penalty is still in active use.